Hi, Lee Phillips here. I want to talk to you about the difference between an agent and a guardian conservatorship. And yeah, I'm a lawyer, still a lawyer, been a lawyer for a long time, don't worry about that. But you're going to come across these terms, guardian conservator and agent in a durable power of attorney. The guardian conservator is generally appointed by the probate court, particularly for an older individual. Kids, parents are basically the guardian conservators, and they can transfer that power for a brief period to grandma and grandpa or something, and I talked about that in a YouTube where I talk about the difference between conservators and guardians. But you've got this court-appointed conservatorship guardianship, and to cut to the chase, the guardian takes care of the physical body of the guy, the conservator takes care of the financial aspects of the guy. Then you have this whole other set of laws associated with durable powers of attorney, and it was in the early 80s that we got this concept of a durable power of attorney. Generally, powers of attorney kick out when an individual becomes incompetent. Well, that's when we need somebody to be able to act on behalf of the guy. So the state started to pass laws which allowed the individuals to have a durable power of attorney, a power of attorney that continued on even when the individual became incompetent. And by the way, the Canadians will call this an enduring power of attorney. In the States, we call it a durable power of attorney. And it names an individual, and usually you give two or three names of two or three individuals that you're going to want your son or your daughter to be the first choice, your younger son or daughter to be the second, and we go down and we pick people who we would want to take care of our financial and our physical needs when we can no longer take care of those. Now, the durable power of attorney, it's going to be a long document, or it can be a long document, pure boilerplate. And this durable power of attorney lists all of the things that this agent can do for the principal. The guy who is incompetent makes out the power of attorney is considered the principal, and the guy that they appoint to take control when they can't control it themselves, physically or mentally or whatever, they are the agent. And this happens. It happened to my wife. I was my wife's agent for 3 or 4 years. She died of a disease called ALS. And during that period, she couldn't see to her own physical needs. She couldn't sign a paper. She couldn't act on her behalf legally. So I became the agent for her. And I could do anything that was listed in this big long list of powers of the agent. And it goes on for 30 pages. You can include in there the healthcare stuff, power of attorney for healthcare. I can see to her health care. I can interact with the doctors. You also include in there that I can turn off her cell phone. I can deal with her bank accounts. And I roll in with the power of attorney and something that says that she is incompetent. Now, in the guardian conservator, the court has usually determined that. In the power of attorney, that's up to you to decide how you're going to declare yourself incompetent. And in my powers of attorney that I write for people as a lawyer, I usually have that upon the signature of an unrelated doctor and the spouse, if there's a spouse, and each one of the children, if there's children, and I can find them, and I actually say locatable and competent children. If I get a document that says dad's out of it, and the doctor signed it, the spouse signed it, and each one of the kids signed it, then this power of attorney will be activated. So I roll into the bank and I show in section 3 or 4 or whatever it is that I've got the doctor's note and I've got the spouse's note and I've got the kids' notes, and I give it to the bank and I say, here's the power of attorney. It says right here I can get into the bank account. The bank will let me into that bank account. They'll have me sign a new signature card with my name as the agent or the person who has access to that account. So it works actually very well, and it saves a lot of time and a lot of trouble because I don't have to go to court and have Dad declared incompetent anymore. I can declare that by however, I mean, you could have your preacher and your doctor, you could have 3 or 4 people, I usually want a couple anyway, signing that says, yeah, I can't do it anymore. And then my agent takes over. So the agent can do whatever the document, the power of attorney, says they can do. The guardian, conservator, can do whatever the court says they can do. And they usually have very broad powers, and in the power of attorney, we give the agent very broad powers. But that's basically the difference between a guardian, conservator, and the agent. The agent's appointed in the power of attorney. And the question usually is, what's the difference between a guardian, conservator, and a power of attorney? Well, the power of attorney is just the document that appoints the agent. They ask the question the wrong way. They don't understand the terminology. So, Lee Phillips, don't forget to subscribe for me, okay? And give me a like every once in a while. I'm talking about the difference between the guardian, conservator, and the agent or the durable power of attorney.